Welcome to the O'Connor Elder Law channel. I'm your host, Melissa O'Connor. Today I wanted to talk to you about timelines that a personal representative and responsible for probating an estate in the state of Florida should be cognizant of. The first deadline that's associated with a probate is that the custodian of the will is required to file it within the court within 10 days of being notified of the decedent's death. This timeline is typically not strictly enforced, but filing of the will within a reasonable time is generally acceptable. But it's in the best interest of the personal representative and the beneficiaries to file the will as soon as possible so that the personal representative will have the powers to act on behalf of the state. Because until until such time that the will is filed with the court, the personal representative will not have letters of administration issued, and therefore the personal representative's obligations begin with the issuance of the letters of administration. So once the letters of administration are issued, the personal representative's obligations begin, and their responsibilities include making sure that the notice of the administration on interested parties is promptly served. So what does promptly served mean? Generally speaking, 30 days from the issuance of the letters of administration is what the courts have deemed as promptly served. The personal representative must also publish and serve notice to creditors. Like notice to the interested parties, notice to creditors is subject to strict statutory deadline, and they must be promptly published. In most cases, that's meant the courts have interpreted that to be 30 days, again, from the issuance of the letters of administration. And it must be published, notice to creditors must be published in an appropriate newspaper for 2 consecutive weeks and must be served directly on any known creditors. So how can you identify creditors? Check the decedent's mail. Many times those creditors are sending him bills and statements. Those would be known creditors, and you could do a diligent search. But proof of publication, proof that the personal representative has actually published in the newspaper for the 2 consecutive weeks, must be filed with the court within 45 days of the first publication date. Another deadline is the filing of an inventory of assets of the estate. The Florida probate rules require that the personal representative file an inventory with the court within 60 days of the issuance of the letters of administration. The inventory must include a notice to beneficiaries' rights and include the estimated fair market value for each item that's listed on the inventory. Another deadline is the final accounting. The personal representative is directed to file a final accounting, including a distribution plan, within 12 months of the issuance of the letters of administration for the estate. So these are all deadlines that a personal representative here in the state of Florida must be cognitive of and have a method and a timeline set out so that way they can meet their obligations. Other timelines and obligations that a personal representative should be cognizant of is that creditors must file claims within 3 months of the first publication, and the notice to the creditors or within 30 days of direct notice, whichever is later. Also, objections. If the personal representative is going to object to any creditor's claims, they have to be filed within 3 months of service of the notice of administration. Surviving spouses, if there's a surviving spouse for this particular probate, they must file his or her elective share of the estate within 6 months following service of the notice of administration, but in no case later than 2 years from the date of death if they planned to make a claim for their elective share. These are just a highlight of some of the deadlines that a personal representative handling an estate here in the state of Florida should be aware of. Always, it is encouraged that personal representatives secure counsel, a probate attorney, to assist them so that way they can comply with these deadlines and with the statutory obligations. However, there's no obligation for a personal representative to have an attorney. They could handle the probate without assistance of counsel, and if so, then they're really encouraged to make sure that they have reviewed and understand the current rules, Florida probate rules, the local court rules, and the Florida statutes to make sure that they fully comply with all the obligations. Should you have any questions or concerns about your specific case, I encourage you to reach out to a Florida probate attorney for assistance. If this content has been helpful to you, I ask that you like and share it with those that may benefit. Thank you.